Many employers require employees to sign non-solicitation and non-competition clauses, also known as restrictive covenants, either before starting work or after. A non-competition clause prevents employees from working at a competitor for a certain period after leaving the company, while a non-solicitation clause allows them to work anywhere but prohibits them from soliciting their former employer's clients and/or employees. Although non-competition clauses are more restrictive than non-solicitation clauses, both can impact reemployability. The good news is that these clauses are often unenforceable. Here's why. First, if an employee is wrongfully dismissed, the non-competition and non-solicitation clauses are often unenforceable. Employers often terminate employees without proper notice. Notice is a legal term which encompasses what you may think of as severance. If an employer fails to provide reasonable notice or equivalent payment, they may not be able to later enforce these clauses against their former employee. Second, these clauses are unenforceable if the employee received nothing in exchange for them. This is known as consideration. If included in the initial employment offer, the job and payment serve as consideration. However, if the employee is asked to sign a restrictive covenant after they have started working, and they do so without receiving anything in exchange, the restrictive covenant is likely unenforceable. Finally, for these clauses to be enforceable, they must be clear and reasonable. Determining what is vague or unreasonable requires legal analysis based on the specific circumstances. If your employer has presented you with a contract including these clauses, consulting with a lawyer can help you understand the implications and whether the risks outweigh the opportunities. If you've recently been terminated or resigned and are subject to these clauses, a legal consultation can clarify your rights and options. If your former employer has taken action against you to enforce these provisions, our lawyers can advocate on your behalf, aiming for a negotiated settlement or representing you in court if necessary. Taylor Janis Workplace Law can help you navigate these complex issues, ensuring your rights are protected and providing expert advice tailored to your situation. Contact us today to discuss your case and explore your options.
At Taylor Janis Workplace Law, we serve the entire provinces of Alberta and BC with multiple offices where we're able to meet in person or virtually. Click the Get Help link in the description for our dedicated intake form to help you get the ball rolling. Our intake team will review your specific case and advise you on the next steps to take. If you found this video helpful, please hit the like button. If you're interested in learning more about employment law, hit subscribe. Thanks for watching.